FICCI's perspective. And we have a leadership who has joined us, Mr. Kapania, Mr. Shrikant, and Ms. Gauri Gokhale from the Committee on Privacy and Data Protection. We have it at FICCI. And the aim of this committee has always been to facilitate and help and work with you guys along with the industry and the government on the process of making this smoother transition on the data protection. The word data protection, I don't think so need anything. It's not been something now a choice. It's kind of a mandatory thing, not a legal obligation, but a strategic direction which can help us businesses to streamline their operations accordingly. And of course, it's something which gives a privilege to the person. We have had a discussion. FICCI has done under the leadership of our chair and the co-chair the sessions when the DPDP Act came in, and we were much awaiting the rules, the draft rules, which has been released now, and the consultation is on. While FICCI would be making his submission to the government based on the inputs received from the members so far, and we understand the new deadline being extended till 3rd of March. The process of coalition at our end across committees is already on, and we've got a good number of inputs from all of you. The purpose of this one is we collaborated with our partner EY, and we are thankful to both Rajiv and Mini to being there with us and joining us, so that we can have a deciphering of DPDP draft rules for all of you, something which can help you to understand how the compliance is going to take place, what are the things which come in place, and how the way forward is going to be there. While one session of 60, I would say 75 minutes may not do the justice to the subject, but we'll try to do as much as possible for all of you in this one. And we look forward to have multiple more discussion based on this. We will try to open up the session for the Q&A once the speakers give their own addresses. You may please place your questions in the chat, and we'll see how much the time permits and we can cover it up. The contribution and the importance of data privacy across regions have been talked about, whether we talk about Europe, you talk about India, or you talk about anywhere else. And there are predictions from the Gartner's report, which says that by 2026, almost 75% of the, I would say, the Indian, data of the people would get covered under the modern privacy laws. And it's going to contribute big way across the different GDPs. The report talks about around 10 to 12% hike, which is a very big one. So keeping that in mind, now I request our chair, Mr. Kapania, Mr. Himanshu Kapania, to kindly start the webinar with his own address. Over to you, Mr. Kapania, for your opening remarks.
Thank you, Sarika. I welcome you all to today's webinar on navigating compliance for the Digital Personal Data Protection Act and draft rules arranged by FICCI in collaboration with the ENY. This session is particularly timely as the digital ecosystem continues to expand at an exponential rate. The importance of data privacy and security has never been more critical. In today's digital world, the simple act of posting information on social media, browsing online content, making an online purchase lead to creation of extremely valuable commodity, the personal data. The phrase "data is the new oil" captures the importance of personal data as a driver for personalization and profitability. The increase in cyber threats and misuse of personal data has led to surge in public awareness regarding individual data rights. Regulators worldwide have created laws governing personal data to safeguard the individual rights of their citizens, such as the General Data Protection Regulation, in short, GDPR, in Europe. To cater to the sensitive balance between the individual rights and technological innovation, the Indian government has enacted the Digital Personal Data Protection Act, in short, DPDPA, in 2023. This landmark legislation will pave the way for transformation in digital governance landscape in India, as the new law imposes obligation on enterprises that handles personal data. Number one, the DGPA has brought data protection to the forefront of corporate governance and operational strategy. It mandates that we revisit how we collect, process, store, and share data. It compels us to adopt privacy-first framework and prioritizes transparency in our interactions with customers, employees, and partners. The role of enterprise and business in compliance with DGPA becomes our second point. As business embraces digital transformation, it is crucial to ensure compliance with data protection laws. The Act and draft rules bring with them a host of new obligations from management to cross border data transfers, as well as establishment of frameworks for transparency and accountability in data processing activities. For organizations large and small, navigating these regulatory changes can seem complex and daunting, but it is crucial to ensure compliance to mitigate risks, avoid penalties, and maintain trust both with customers and your stakeholders. The DPDPA has brought data protection to the forefront of corporate governance and operational strategy. Understanding the key provision of the DPDPA is essential for every organization. The law introduces several fundamental concepts such as data fiduciaries, data principles, and consent-based data processing. It underscores the rights of individuals to access, correct, and erase their data while placing obligations on businesses to ensure data security, prevent breaches, and report incidents promptly. The draft rules further elucidate the compliance landscape, specifying the operational mechanism to implement these principles. From consent management framework to grievance redressal mechanisms, the rules provide clarity on how businesses must align their processes with legal mandates. Yet, the compliance is not merely about avoiding penalties, it's about earning and retaining trust. Consumers today are more aware and discerning than ever before. They demand transparency, security, and control over their data. Organizations that embed privacy and data protection into their DNA will differentiate themselves, foster customer loyalty, and drive sustainable growth. Moreover, regulatory frameworks around the world are converging towards stronger data protection standards. From the Europe's Union GDPR to the evolving data privacy laws in the United States and Asia Pacific, data governance has become a global imperative. For Indian businesses with international operations or aspirations, aligning with the DPDPA not only ensures domestic compliance but also positions us favorably in the global marketplace. Therefore, the context for the webinar, Navigating Compliance, Understanding Digital Personal Data Protection Act and Draft Rule, becomes very critical at this juncture. At FICCI, we understand that these evolving regulations present both challenges and opportunities. Today's session will provide a valuable platform for industry leaders and experts to come together, share knowledge, and discuss practical steps to ensure compliance with the Digital Personal Data Protection Act. Through their guidance, we hope to address some of the pressing questions on our minds. Number one, what are the immediate steps organizations should take to align with the DPDPA and draft rules? Number two, how can business leverage technology to automate compliance and enhance data security? Number three, what roles does a leadership play in driving a culture of data responsibility across the organization? Number four, how can we ensure that our compliance efforts not only meet regulatory requirements but also create business value? Our distinguished panel of experts will offer insights into the key provisions of the Act and the draft rules, highlighting the critical aspects that businesses need to focus on. They will also provide actionable strategies on how organizations can align their operations with regulatory framework, safeguarding both their business interests and privacy of their customers. FICCI is proud to support this initiative like that will help business stay informed and ahead of curve in the era of rapid regulatory and technological changes. We recognize the importance of fostering collaboration and dialogue in these critical areas. Today's webinar is a perfect example of that commitment. As we proceed with today's discussion, I encourage you all to actively engage with the speakers and panelists and ask questions and share your perspective. The insights shared today will not only help us to understand regulatory requirements, but also equip us with the tools and knowledge to navigate the evolving compliance landscape. I would like to thank all our speakers and attendees for joining us today, and I look forward to an engaging and insightful discussion. Let's get started. Over to Sarika.
Thank you, Mr. Kapania. Thank you for setting the stage as a chair, and of course, getting a perspective from a conglomerate like Aditya Birla. We understand the implications of data when we talk about individual businesses as well as the conglomerate, what kind of things it came in. From you, we directly move on to our co-chair, Mr. Srikanth Rajgopalan. Mr. Srikanth, over to you from your perspective as a co-chair and also as from the fintech industry, since you were heading the Perfios aggregating, you're the CEO for that one, the Perfios aggregation services. So what do you feel could be the implications of the DPDPA draft rules, and how do you see it more going forward? Over to you, Mr. Srikanth.
Thank you, Sarika ji. And honestly, Himanshu ji, thanks for making my job so much easier. I love the way you framed regulations as an opportunity to earn trust versus just an overhead to be complied with. I think if we start with that mindset, and if we start with the fact that compliance is a trust building activity, then I think a lot of executive, strategic, and operational decisions become much easier. I'd like to offer a kind of a worm's eye view of what we have experienced in what is called the account aggregation space. For those of you who may not be familiar with the space that we operate in, the account aggregators are basically consent managers who operate in the financial sector. We were formed as part of a 2016 RBI master directions. And there are plenty of us in the market today who essentially our job is very narrow. We serve as consent managers who allow data principals to share the data from one financial institution to another. There are safeguards around what data is shared, how frequently it can be shared, the life of the data, its end use. So there's a lot of things that have been codified. As you can imagine, the first year or so was more about figuring out the operating metrics, but I'm happy to report today that the adoption and the business value that financial institutions are seeing in adopting a regulated, consented data framework is there for everyone to see. Later, after this webinar, I'm happy to share some links to industry data that Sarika ji, you may want to share. But I think one thing that is standing out to us is once we introduce a regulated, smooth, and compliant way of data sharing, there is no going back. Adoption is superb and it's going through the roof. The two other things that I think we should think about is, yes, it is great to have a digital economy. Yes, it is absolutely great that more and more citizen services products are offered in a completely digital and presence-less way. There are oceans of data over there, but I think as fiduciaries, we should keep in mind that with great data comes great responsibility, and we have to act responsibly on behalf of the customer. And finally, I think all of us are aware of the sheer transformative potential from AI products and solutions. Let's also keep in mind that the data that these AI models are trained on are also as subject to privacy laws as any data that we share. So with that, I think I would like to set a context to this webinar to say that a lot of this in terms of consent management is already operating at scale in the financial services sector. And we'd be happy to share whatever learnings we can, wherever it applies to other members of the industry. With that, thank you, and back to you, Sarika.
Thank you, Srikanth-ji, and you have actually raised on the subject which is going to get covered by our expert from EY, Mr. Rajiv Chugh. He is, and we're thankful to EY for partnering with us. And Rajiv ji is a partner and national leader for policy advocacy and specialty services, EY India, and he's going to talk about the subject where you just touched upon, where DPDPA, regulatory overview, and interplay with other policies. I think, Rajiv ji, that is something which the industry is really looking forward with so many things and regulations coming in place. How do we really I mean, how do we really cope up with the other policies and this DPDP Act in place now with the draft rules in there? So over to you, Rajiv ji, for your address, and then to answer the queries of the people which they are actually putting up in the chat also. Over to you.
Correct. Thank you so much for giving us this opportunity to partner with FICCI, and Mr. Kampani and Srikanth for obviously setting the tone. The first thing that I want to start off with is that today, is my slide visible to everybody? Before I begin,
No, not yet.
No, Rajiv, we cannot see your slides.
1 second. Now,
Yeah, but you need to make it full screen.
yeah. Okay, is this clear?
Yes.
Super. Great. Firstly, so I'll repeat, thank you so much for giving us this opportunity and setting the context behind the DPDPA, which is the Digital Personal Data Protection Act, read with the draft rules. Before I begin, one of the things that I want to highlight to everybody is that, and this is something I picked up from the newspapers, data breach is real and it is happening. We've got increasingly number of data breaches which are happening in India. And the worst part is that India today is ranked as the 5th in the order of preferential, and the country is getting hacked as number 5 in that league. That means there is a lot to be done in terms of building a strong privacy framework. And hence, I think Data Protection Act, which is coming in to protect your and my rights as a data principle, are going to be very important in the near future. Now, before I get into the nuances around this, I want to just set the context.
Rajesh sir, sorry to disturb you. This is not the full screen. Can you please move it to the full screen, please?
It is full screen right now.
Sir, request you to please click on display settings. The top of the screen, the display settings, and then
Yeah,
duplicate.
1 second. Yes, I'm going to the display settings.
Duplicate.
Is this better?
Yes, sir. Now it is perfect.
Okay. Okay. So, okay. Thanks for that. Now, before I get in, I thought I would break this slide into 2 parts. First, tell you why are we talking about DPDP? How does it apply, and what is it that it means for us? Firstly, back in August of 17, we had the Supreme Court come out in a judgment on Puttaswamy case that there is a right to privacy that each and every Indian citizen requires. Based on that, there was a Justice Shri Krishna committee, which was enabled to create a white paper on what should be the data privacy law in India. They went through all the laws which were there in the various countries and have come back with a draft. One very important thing that happened in this journey when we are looking at it till July 23 and before the law got passed in August of 23 is that there was a criminal liability being imposed. However, the criminal liability has been done away with, and we have come back with a financial penalty. So if you are non-compliant with any of the provisions of the law, there is a financial penalty which has come in. Unfortunately, that penalty is very high. They're talking about a penalty up to 250 crores. And in case we are not able to do some other things in the rightful manner, another 200 crores. So at a given point of time, the exposure can be as high as up to 500 crores or more. Now, while we use the word up to, it doesn't mean it will happen, but that's the way the law has been worded. The second thing that is very important is that after 16 months of the law coming in, we've finally got the draft rules on 3rd January. The public consultation was initiated till 18th of February. It has been extended now till 5th of March 2025. I would urge all of you who are affected by this to please send us your comments so that we can put it in a consolidated manner. 3 consultation meetings have already happened, one in Delhi, Mumbai, and Bangalore. And I'm going to talk about that at a later stage. But before we do that, what is it that you need to know? Now, let me tell you something. My name is Rajiv Chugh. I go to a chemist and I tell him I want a blood pressure medicine XYZ. And I give him my mobile number for him to send me the bill. He does that. Does it mean that my data has been breached or I have shared my data voluntarily? Or now take a situation that every month I repeat this activity. Then in the month that I don't go, the chemist gives me a call to say, can I offer you your blood pressure medicine? Because you have not come back to me. Now, suddenly, the way in which the information that was communicated by you to a person and it has been perceived by him, processed by him, and reverted back to me has changed. Now, that is what the data privacy is trying to do, that if that information is given to somebody, which we will give for availing goods and services, does it mean that person can exploit it or process it to further his business gains without my consent? So this law lays the background around this. And obviously, this law, if I look at the left-hand side, applies within Indian territory where personal data is collected in a digital form. Suppose I do not collect it in a digital format, I do it manually, and later that person digitizes it. So that's where it becomes digital data, which would need to be checked into by that person. Now, where I share my data with you and you record my phone on your mobile phone, obviously, the law will not apply between two people interacting with each other. And personal data, which is being made public, I go to a LinkedIn, I put all my data in. Now, I have voluntarily decided to share the data. So the question is, to what extent LinkedIn, which is a data fiduciary, which is storing all my data, would be responsible for my information? Now, very interestingly, this law has also created a nexus to people who are collecting individual data for the purposes of offering any goods and services. Let me give you an example that I was dealing live with. There is this organization which is in the gaming business. Now, when a children or an adult wants to do a gaming, he registers his name, contact details, credit card details for the purposes of downloading the game or playing the game, as the case may be. Now that game is somewhere in a jurisdiction in America, Japan, UK, wherever it is. This concerned person now has data. He will obviously be doing a behavioral analysis to see what are the games I like. I will get targeted advertisement. I may get upgrades on the game or whatever purposes are there. Now, is he also covered? The answer is yes. This law also says that if a data of an individual, now the complication happens when that individual happens to be a child below the age of 18, there are a little bit more requirements coming in. So I just want to leave this forum for you to see within India and outside India, look at your business, the way you are capturing it and your parent companies are capturing it for this purposes to see the applicability. Then we come into the next stage, which is basically, I have decided that rather than complicated, let's only look at data privacy in these 5 pillars. The first pillar is data principle, which is you and me, our data, which is collected. The second pillar is the data fiduciary. That's the name which is there. This means any person who collects my data and determines the means for processing of that personal data. So a company which is collecting the data comes back and is basically going to be responsible for maintaining the data for a data principle. Now, pillar 1 and 2 have to be synonymous with each other. But however, I'm jumping you to pillar 5. The law has carved out little bit of benefits and exemptions to say that if certain data is collected for legitimate purposes or uses, then to that extent, my liability under this law would not be there. Now, the first one is data which I voluntarily provided, like the way I said. To provide any subsidy, benefit, or performance of any law, Now, what would be a performance of any law? If you're working in an organization, you give your data. Now, if you give your data, then two things happen. One is that I will process your information for issuing your Form 16, let's say a salary or a withholding tax certificate. So I have all your details with me. The law wants to do a survey or wants to assess. I may want to retain those records for a period of, let's say, 6 years or 8 years, depending on the law that we are talking about. So that becomes the performance of any law, which will require you to maintain. So if you're in the insurance business, let me give an example. It says that when you take a policy, and suppose you pay your first premium, you do not pay your second or third or fourth premium, the insurance company under the IRDA guidelines, and that's where the other guideline comes in, has the power to contact you for a period of 2 years to follow up for payment of premium. So what would you do? That means even though you have refused to do it, the law has said that that data fiduciary can continue to process your data because it is required under any law for them to enable renewal of the premium as the case may be. So this is something that applies to sectors. You could be in the fintech, you could be a non-banking financial company, you could be a bank, insurance, that may require you to retain data beyond the minimum period. One more thing, which is the last part, is for the purposes of employment. So if I take data, the moment you become an employee, as an employer-employee, there are certain protections which are built in that I can use that data for the purposes of ensuring that you are my employee and you're going to meet with the necessary requirements within the legal employment that exists. However, now let's take an example that as an employee, you're entitled to a medical insurance. Now, when you take medical insurance, what happens generally? If you're married, or even if you're not married, you would have your spouse, your children, your dependent parents whose data you would furnish. Now, that data which is coming in, is it for a legitimate use or it is something that I need to comply within the nomenclature to be able to meet the requirements of this data privacy law? Hence, the center pillar, the number 3 pillar, becomes very important for all of you to take care that whenever as a data fiduciary, you're taking up data of a data principal, is the consent being taken in such a manner that the information that is available to you for processing, storing, has a proper consent. Now, consent means any freely given, specific, informed, and unambiguous indication by data principal of their wishes by way of a clear affirmative action signifying agreement to the processing of their personal data for the specified purpose. Means if I'm entering your organization, let's take another example. I'm a candidate. I come to your organization. You don't make me an employee. The fact you don't make me an employee, I'm a candidate. You decide to retain my data because you may have a cooling off period. You may want to put me on a bench, or you may want to give me a thing that I can only reapply to your organization for a period of 6 months. In all the reviews that we've been doing, we find that the data with the HR team has data of employees, which is, of people or candidates who have not become employees, which is there with them, which is being used and can lead to a data leakage and hence affecting the rights of a data principal. Now, obviously, all this I'm taking for the purposes of processing, which is my pillar number 4, for the purposes of storage, structuring, retrieval, use, alignment, as the case may be. In India, you as the data fiduciary will always be responsible for any data which is processing, whether you do it directly or indirectly. Suppose for your payroll or other processes, you ask somebody else to process your data. Now, there's a data leakage there. Now, the question that will come in is that you as the data fiduciary, did you take reasonable steps to ensure that the person to whom you were giving the data, was it encrypted? Was it masked? Or was it of such a nature that you were able to ensure that in the event of a breach, it is perfect and it is okay? So these 5 principles lay down what needs to be done. Now, one thing I just want to highlight is whenever there's a personal data breach, you have to look at all the laws which come under the law, which is the Information Technology Act, the IRDA, the SEBI, the Telecom, Direct, Indirect, and the Labor Law. One thing I want to highlight to you is that the Information Technology Act has within it what is known as a Computer Emergency Response Team, which is called CERT. The IT Act requires that if there is a breach, we should intimate to them within a period of 6 hours that a breach has happened. Suppose we are not able to do it within that 6-hour period, then the information they feel will go in the dark web and it will not be able to retrieve the same. So CERT is always searching the dark web to be able to see where the data is. So one of the things that came out in the roundtable is what is the level of breach which should be subject to the DPDP? Is it all breaches? Is it minor breaches? So that's one thing that we need to represent with the authorities to see that what is it. Obviously, all this leads to you as an organization, and I have my colleague Mini Gupta coming in, and she'll be basically talking about the technology and the tools that you would need to ensure that things happen properly. But for you as an organization, policies and procedures that you have, cross-border transfers, currently there are no restrictions. But the India may come back and specify certain countries where they may not want you to store the data. SDF is a concept of a significant data fiduciary, means a person having a large volume of subscribers who may require some additional requirement of performing audits. So currently the draft rules talk about a gaming, a media, and a commerce company having 2 crores more subscribers and a gaming having 50 lakh subscribers. They would need to do periodic assessments. Last 1 minute from my end, if you have not taken reasonable security safeguards to prevent personal breach, there is a 250 crores penalty. What is reasonable is something that you need to build in to see that have you taken steps to prevent the right thing? Do you have your systems in place? Are they IT compliant? Are the softwares being updated? Like I said, failure to notify the board and affected principals of a personal data breach. IT Act says 6 hours. DPDPA and the rules say you should immediately let us know about the breach, and within 72 hours let us know what are the steps you've taken and have you intimated to the data principal that the breach has happened and this is the data which is lost. And obviously for children they have much more requirements which are there. So hence I think there is an urgent need for all of you to focus on getting your systems right. And one of the things that we want to leave with you is that there is a need to build your compliance roadmap. In fact, in the meeting at India Habitat Center in October 23, when Honorable State IT Minister Rajiv Chandrasekhar was there, he indicated that the act is in place and hence there is an urgent need for all people to develop a comprehensive compliance roadmap and ensure that wherever there is an interplay of other laws, we prepare a legitimate use document to protect us and build a reasonable case of why penalty should not be levied on us. Thank you. With this, I will pass it on to my colleague, Mini.
Thank you, Rajiv ji, for putting up the perspective with respect to the various policies that are existing, the principles for the data thing. And of course, now talking about the compliance, we have Mini Gupta from EY again. Mini is a partner and national leader for data privacy and data protection, technology consulting services, EY India. And she is going to talk about the key considerations and readiness for the compliance journey ahead. Mini, we did hear Rajiv talk about the various perspective. We did hear that the things across policies need to be taken care of in what way. Now the compliance is something which everybody is looking forward to. We look forward to your suggestions that how the compliance journey can be made easy and the smooth for all of us. And before you start, just an announcement for the participants. We do understand there are lots of questions which are being put forward in the chat. Can we request all of you to please restrict the questions till the end? We have the speakers finish up their chat. So maybe some of the questions of yours will get addressed during the presentations with the speakers are making it. Else, we'll try to cover up as much as possible once this is done. I mean, the addresses are over. Also, we've got the request from others that they are actually, the chats are disturbing them. So we request you humbly, please keep that thing restricted towards the end part of the webinar. We'll definitely try to cover up as many questions as possible. Over to you, Mini.
Thanks, Sarika. Am I audible? Okay, super. So thanks, Rajiv. He set a great context, and of course, all the speakers before, and now everybody wants to know what does it mean for us? What is it that we really need to do? So like Rajiv mentioned, yes, the act was there. Now we have the rules. There are quite a few areas in the rules. What is important to note is there are 22 rules that have come up. 12 out of those are impacting corporates or data fiduciaries directly, which are of key focus. There are others which are related to Data Protection Board with respect to the state and its instrumentalities and with respect to other definitions, etc. But there clearly are areas that we need to look at, and we'll probably deep dive into a few of those to see what does it mean from a compliance point of view. So overall, if you look at it, the DPDP Act compliance, and there are many activities that we need to do. In some cases, organizations are already compliant to global regulations. So for example, GDPR has been done, or CCPA now, CPRA has been complied with. So there is a global frame that exists. So they just need to extend it to DPDPA. In some cases, we're obviously an Indian organization starting afresh on this journey, and there is a lot that needs to be done. Irrespective, even if you are compliant to GDPR here in India. So one is where we have a framework at the global level, which can be extended to India. The other is where within India, we probably complied to GDPR across all our processing activities in the country. Still, what is needed to be known is there are specifics to DPDPA. And hence, what we need to identify is what does the privacy control matrix now look like for us? So if you're starting fresh, it's the entire DPDP and all the provisions of the Act and, of course, of the final rules that will come in. And if we are already compliant to other global regulations, then what are those nuances? Let's take an example. GDPR has 6 lawful bases. The Indian Act only talks about 2 lawful bases, which is consent and legitimate use. So that's a big change. Another example is parental consent. In India, we need verifiable parental consent, unlike GDPR, where verification of parental consent is not required. That's a big animal in itself. How would we go about it, right? So another example is right to nomination. GDPR or any other regulation does not really talk about the right to nomination, but Indian Act does. So similarly, there are many such nuances which are very peculiar to the Indian Act. So even if we are on a global journey of compliance, let's identify our privacy control matrix to see what would be applicable to us. Even as a journey that's starting afresh within India, we need to ensure that we look at our business. We look at what are the kind of data principle types that we're looking at, and hence what could be applicable. So if our business does not look at children's data at all, then that's one element that may not be applicable. But if we do, then there is a whole lot of obligations that come into play. Similarly, however, if we are from the education segment or a healthcare segment, then we also enjoy certain exemptions when it comes to children's data, right? So the privacy control matrix becomes very important. The next is, of course, once we have what is applicable to our business, what is contextual to us, given where we stand already, is the current state assessment. For the applicable provisions, we need to assess where do we now stand? What is the gap? Obviously, we didn't really need to comply with this earlier. Now that we have the Act, what all will we need to comply with? What would the journey look like? So that current state assessment becomes extremely important. Now, in our experience, this current state assessment is incomplete if we do not look at other sectoral or other regulations in the country also. So that's where we come in to say that while we're looking at, say, DPDPA and the implication and the current state, have we overlaid, say, what does, say, an RBI say with respect to some of the clauses or some of the provisions that are overlapping? Or what does the TRAI say? Or what does the SEBI requirements need? So a current state assessment in context of the applicable matrix, as well as other regulations applicable to us, which have overlaps with the privacy regulation, is extremely critical. Then comes the element around visibility, right? How will you comply if you don't know what you need to, what is it that we're trying to protect? What is it that our exposure has? So data discovery and classification becomes extremely important. This is a phase, and this is quite an onerous phase. In fact, data discovery, classification, as well as the whole mapping of how this personal data pans out within the organization and also external to the organization. So we know under the Act there are zero provisions or zero penalties for a data processor. Hence, as data fiduciaries, we need to identify where all does this personal data go, not just within the organization, but outside as well, so that the right measures can be put in place. So this visibility, which is item number 3 and 4, is extremely important. And in our experience, this needs time. This takes time. So if we have already done, say, other global compliances, we already have a latest updated version of personal data as well as the entire mapping, then we really have done quite a bit of activities that would have otherwise taken time. So we can now focus on the remaining. But if we haven't, if that has not got extended to the Indian processing activities, or we are embarking on this program fresh, then trust you me, irrespective of what timelines are given by the rules, we would sincerely urge that you should complete this activity, because it needs time. It needs an understanding across all the business processes, across all the applications, or the entire footprint, including the third-party ecosystem, the entire supply chain, to identify what does our overall visibility look like with respect to personal data and where it pans out. So from our experience point of view, we can tell you the activities 1 to 4 that we've chalked out on this compliance roadmap is something that you should begin with if you've not already started with. This is an immediate requirement now that we know that the final rules also will be expected soon, and we will then have the timeline to comply. But these activities need time, because after having done this, there are many more steps that we need to take. So once we have all the footprint, we have all the touch points where data is present, we need to put down our notices and consent banners. We already know that from the Act as well as now rules point of view, it's prescribed what the notice should contain. We also have the linguistic implication when it comes to notices around the 22 Indian languages having that option. So we'll need to look at all those elements as we draft the notices and consent. And like our colleagues have mentioned, consent, of course, has to be itemized. It cannot be a default tick in the box as part of your terms and conditions, but it has to be an explicit opt-in. So what are those various components of consent that we need to lay down? However, it cannot be too much. We have to keep in mind the user experience. Whatever we put down as part of the implementation, we keep it very, very succinct. We keep it limited to 3, 4, max 5 line items that a user can look at and simply consent to. So in this entire compliance journey, we need to bear in mind the business imperatives. We need to bear in mind the user experience as well. The next activity is privacy impact assessment. Of course, this is more about risk assessment. This is about identifying the prioritization when it comes to implementation. This is a step that we recommend, not mandatory for every data fiduciary when it comes to DPDPA. However, this helps us prioritize from an implementation point of view. Like I said, there are no obligations directly from the Act, but as data fiduciaries, we need to ensure a strong third-party privacy risk management program. This is also an opportunity to probably optimize the third-party ecosystem that we have. Look at those third parties which are well governed, where we can enforce contractual clauses. At the same time, how do we build in a due diligence and a governance mechanisms while dealing with these third parties, both prior to the engagement as well as during and on completion of the engagement as well. Then comes the whole design and documentation. Like I said, even if we are compliant to other global regulations, there are processes unique to India that will have to be developed. As a company embarking on this for the first time, there is a whole set of documentation that needs to be put in place. So whether it's your privacy policy, whether it's breach reporting, whether it's consent management, whether it's principal rights management, all of those elements will have to be looked at when we're doing the design and documentation. So there is a whole lot of documentation that goes in there. We should ideally set up a privacy office. Now, you would know under the Act, the designated DPO is only required when it comes to data, significant data fiduciaries. However, when it comes to any and every organization, you should set up a privacy office. You should set up, you should identify who would be overall accountable from a privacy point of view, who will be responsible to manage grievances, who will be responsible to manage, any sort of interaction when it comes to the data protection board. So setting up the privacy offices, the roles and responsibility, the privacy champions, that whole structure becomes extremely important. Then comes the whole element around implementation rollout. Now, that doesn't have to follow sequentially. A lot of these activities can happen parallelly as we identify the various obligations and the steps ahead. Audit and review, again, is a step that comes in at a later stage. Mandatory, of course, if there is a significant data fiduciary, we need to have annual audits. But if it is any and every organization, you should have your own internal compliance checks, at least on an annual basis. Now, while we do all of this, in order to sustain our efforts, it's extremely important to leverage technology. And there are several privacy enhancing technologies, privacy automation solutions that are
Vinny, we can't hear you. I don't know, is it my end or with everybody? No, it's with
No.
everyone. So,
Yeah.
Vinny, we have lost you.
So
Maybe
I
you'd
think,
like to reconnect?
yeah, I'll just complete it. Basically, there are privacy enhancement technologies and automation which is coming in, and obviously this was alluded to earlier also. So you need to decide what is it that you need to do to ensure compliance. So this is the DP/DPA compliance journey that we wanted to put before you. Do have a look at it because it will help you meet your goals and objectives of corporate governance and data protection. Back to you. Sarika ma'am, back to you.
Thank you, Rajiv ji. I'm just waiting for Minnie to come in.
I think connection got lost maybe.
Yeah, because I can't see her. Maybe by then, if any,
Yeah,
okay, she's
Minnie's back.
Sorry, can
Over to
you
you,
see
Minnie.
my screen?
No, we
Yes,
can't.
Minnie, you're audible. You're back on.
You're audible, but we can't see your screen if you're sharing a presentation.
Okay, so while we talked about the various steps, one thing that we need to keep in mind is, of course, the training
Sorry,
and
Minnie, to
awareness
intervene.
program.
Are you sharing any presentation?
I'm bringing it up, but I'm just talking till then.
Okay, okay.
Right. So one thing that we need to definitely ensure is the training and awareness. This is an activity that goes hand in hand. We cannot keep it, say, for a point in time, but this is an activity that we need to ensure runs through the entire program. And it's a part of the change management. It's actually a part of the entire life cycle of as we do compliance. So it's not a one time. It has to be role based. It has to be, periodic reinforcement to say what we need to do. So while we talked about that in terms of the compliance journey, let me take you maybe through a little more in terms of what is it specifically given all these obligations, right? And I'll just take a couple of them just in the interest of time. So when you look at data principal rights, for example, so while we've said we need to run the whole compliance journey, but say for data principal rights, what do we need to do? We need to actually redesign our internal processes. We need to establish these processes of rights management. We need to have our systems in place, say technologies in place to say, how do we do this? If someone says right to know, if someone says right to erasure, how will this actually be done through our systems? Are there ways and means of pulling the data up? Are there ways and means of deleting data uniformly across all touch points? So enhanced record keeping, system modifications is something that would be critical. Of course, we may want to leverage automation when it comes to the whole workflow around rights management, because if there is an obligation, if there is a law that needs you to keep data longer, even if one was to exercise their right to erasure, we are in our rights as data fiduciaries to deny, because we are obligated to keep the data longer, right? So how do we leverage, how do we ensure that those elements are coming into play? And of course, all of this cannot be done without the training and upskilling of our staff to say how will they handle each of these rights as they come up. Maybe we'll take one more example. So for example, on data retention timelines, right now, this is something has been explicitly called out in the rules for certain 3 classes of data fiduciaries, like Rajiv mentioned. But overall, if you look at it for all of us as data fiduciaries, the Act says it's a purpose-driven or a purpose-led retention, which means we need to identify the purpose per processing activity as to why are we collecting it and when will the purpose really end, and accordingly build the whole retention schedule. So this retention schedule is a large exercise. It needs to be updated as well. Second, we also need to look at what are the other obligations from other laws. And that's where our GCR team collapse, and hence from that perspective, what should the retention be? The other element that we need to keep in mind is data purging post-retention period. So while we've got retention, how do we ensure that the data is purged, not just from our internal systems, our backups, but also from our data processors? So that's again an extensive exercise. And for those 3 specific classes of data fiduciary, which is e-commerce, social media, gaming, I mean, imagine now they need to have mechanisms in place to monitor inactivity for all the registered users, identify whose 3-year period is approaching, and then send out those intimations to all those individuals 48 hours prior and let them know that their data is going to be deleted. And if they come back saying, okay, we need to delete the data, if they come back saying not to delete, then we need to retain and reset the flag as well. A big change in the entire platform, a big change in the way they're processing data and the way they're retaining data. Right. So these are just a couple of examples. Just in the interest of time, I'll not get into each one of them. But what is important is across all of these, we need to get into the specifics. We need to do a scenario-based analysis in context of our business to identify what's applicable and what are those obligations and how do we comply. So thank you so much. This is what we would like to cover right now, but of course, open for questions, and you can reach out to us at any point later as well. Thank you. Over to you, Sarika.
Thank you, Mini, for sharing your views on this thing and about the various aspects of the compliances and how we need to get well prepared, and how the data protection or role of the DPO and other things which are come into the perspective. So I'll not be repetitive on the same stuff. I come on to our last speaker, but not the least, definitely, Ms. Gauri Gokhale. She's a co-chair for our committee as well, and of course, a leader in TMT, an expert who have been working with us for long. So over to you, Gauri. How do you see the way forward for this? And then we open up the floor for the audience to raise questions and our experts to answer the same. So over to you, Gauri.
Thank you. I must thank EY to take this initiative. It gives me an opportunity also to sort of call for action on what is happening, as a committee that we are working on. So I think I'm just going to be, very quick in terms of what we are expecting from the industry, all of you, because for us to, sort of implement this law, there are multiple steps still to be undertaken. And we need to work, as an industry organization, as your, representatives, and make relevant representations to the government. And I'll explain 2-3 steps involved where we will need your assistance, right? So what we are doing is, apart from, responding to the rules, if you really see, even during the conversation that, EY team had, you will realize that there are certain uncertainties in terms of interpretation of the Act itself, right? As was mentioned, for example, the employee, data exemption, right? So what we have done is, as a team, we have prepared a list of FAQs, which answers you will not get in the rules, because those of you who are, from the legal profession, you will understand that, the rules can't go really beyond the Act, right? So the rules have to be within the framework of the Act, But if you have to interpret the act, there is some guidance required for us, all of us actually. And unfortunately, we don't have a regulator as such under this law, right? So MeitY is out there, to support us, but the board, which has been constituted under the act, is only going to be an adjudicatory board to levy penalties, to put it simply, right? But if you want to get some guidance, we will have to look at MeitY and not the board constituted under the act. So number one, we are preparing FAQs just to get even a clarification in respect of some of the provisions of the act. The second thing, apart from the rules that needs to happen in some of the notifications that the government needs to come out. For example, who will be treated as significant data fiduciaries, right? In terms of exemptions, right? There are certain exemptions. For example, startup exemptions that we have under under Section 17, right? So some of these specific exemptions and inclusions is something as also the data transfer, right? That we have, which are the countries where the data may not be transferred, right? So some of these steps are yet to be taken by the government vis-a-vis the implementation of the act. So we definitely need clarity, because for example, as EY team said, that if you are supposed to plan out your activity and suddenly after 5 months you are told that you are going to be treated as a significant data fiduciary, then some additional steps may be required from your side as is expected under the act and the rules, right? So for you to envision as to what all you should be required to do, it's important that we need to get this clarity along with the rules. With respect to the rules, thank you, those of you who have contributed. We have received hundreds of pages of comments on the draft rules, which the team is in the process of collating. Sarika and her team have helpfully collated it, and I'm in the process of, reviewing those rules. I'm just going to highlight some, 7-8 items which are on the table where we have received maximum sort of inputs. But also, if you have some additional inputs, please feel free to. This is the time, as the timeline has been extended, but this is the time all of us need to give back, frank feedback to the government. And I believe government is willing to listen, because, I was part of one of the MeitY consultations and they seem to be open to receiving suggestions, right? So notice, right? The feedback that you have received is some members want a specific format of the notice, so there is consistency. Some are saying, I'm just going to be a little upfront here to give you how diverse inputs you have received, and we'll need to collate all that as a single voice. So one approach is give a specific format. Others are saying don't micromanage, we will figure it out, right? So what is a balancing approach we need to figure out? Some have given inputs on the oral consent, because in the Indian context, not everybody is literate, right? So how do we align the consent? Suppose you have taken oral consent, right? So that there is some clarification required, as some industry members are saying. Then on the language, as EY team said, right, there are 22 languages. Can we request the government to say that only the languages that the platforms are supporting, only the consent should be, or the notice should be only in those languages, right? So these are the clarifications we need. The most important part we have got feedback is for the past data. Now, Section 5.2 talks about, sanitization of the past data. So what are the timelines? What is the manner in which it should be done? Not much guidance has been provided in the rules, right? So we are going to ask for that as well. The next thing is on the reasonable security, practices. If you really see, again, there are two divergent views coming in. Some are saying, please give us specific, standards that we need to comply. Some are saying, please don't, even give these 9 points, because, different types of data sets may require different types of, security practices. So if the data sets are very basic, please don't expect so much encryption and all of that from us, right? So that is the, two divergent views again coming in, but we will sanitize these views and give a perspective, to the government. On data breach, unfortunately, the main act itself doesn't have a materiality threshold. So we have received lots of feedback to say that please put materiality threshold. As I said, the rules can't really, sort of contradict the act, right? So maybe the government hands, may be tied, the ministry's hands may be tied there, that they may not be able to, put in a materiality threshold, which is not in the main act. But there are definitely feedback on the timelines, which we are taking into account. And of course, we will put materiality threshold also as a request. Let us see where it goes. But that is the other quick point. Then data retention periods. Only 3 entities have been called out in the schedule. So there are 2 approaches. Whether no entity is called out, and and we give the feedback that let the act determine what needs to be done, purpose driven approach. And if the purpose is served, then then maybe you can prescribe certain timelines, but they have given only for 3 types of entities. Should there be more types of entities included? How do we do when we have to still keep an account open? So for that limited purpose, some data may be required. So there are certain questions about data retention period as well. Children's consent, the government has said we want to also adopt the principle of data minimization along with this. So children's consent is going to be a big question mark as to how we manage that in terms of verifiable parental consent. So we still do not have full clarity, and there is a lot to be proposed. But one thing we will definitely propose is the exemptions. I think EYT mentioned there are 2 types of exemptions on education and health. Can we think about more exemptions, so long as the data is not used for harmful uses? Then some of the other additional exemptions also could be proposed. So that is one area we will probably put feedback as well to the government. And the last couple of things is there is an indirect data localization for SDFs that have been proposed under Rule 412-14. We have again received a lot of response on that, so we will definitely give a feedback on that as well, because obviously it becomes very complicated to see that certain data maybe should be in India, but certain could be abroad, and it's going to be a sort of nightmare. So long as Section 16 is followed, don't add additional complications for SDFs is what we are going to also propose. Consent management framework, as Shrikant rightly said, it's an important framework, but a lot still needs to be done vis-a-vis the consent management framework. For example, what is the revenue model of the consent managers, right? The second one is, how is the API integration going to work? Third one is, how can the consent manager be blind to the data? What are the steps in which that is an expectation? What is the security measures that the consent manager should adopt? So there are a lot of queries, even conflict management, which has been proposed in the schedule, schedule 1. So there are lots of questions around that as well. And the last is the government use and the government request, and the government request for information, which comes under Section 36, which is very, very open-ended. So there are anxieties, with the organizations as to when the government seeks data, what am I supposed to do, right? Some guidance, more guidance is required, is what the organizations are saying. So this is a quick snapshot of what we have received thus far. Of course, there is a lot more. As I said, it's hundreds of pages, but these are the areas where FICCI team is focusing on. And thank you again for sending your feedback. As I said, 3 steps: FAQs. Second one, all the exemptions, notifications, we need to work with the government even on that. And the last but not the least is the rules feedback that the team is working on. So this is a quick snapshot on way ahead. Way ahead, of course, EY team has excellently provided in terms of at the organizational level what steps you should start taking. But at an industry level, just to get the law framed and finalized in a manner which is conducive to the innovative, for innovation or AI usage and whatnot, right? But at the same time protecting data principles sufficiently, right? So how do we balance it out? That is what the FICCI team is, as a committee, we are working on. And we will definitely need your support to finalize and give relevant representations to the government. So with that, I hand it back to Sarika ma'am. Over to you.
Thank you.
If it's okay, Sarika ji, sorry,
please,
just
please go ahead.
one follow-up, and perhaps Gauri or the EY team can respond to this. There was a provision for data processors in an earlier version of the regulations. It seems to be there in some forms or manner with a very limited set of responsibilities. Now, it's very, very likely that of the 500 odd people who are on this webinar, then there is a set of entrepreneurs who are processors and not necessarily fiduciaries. And it would be useful to give some guidance in terms of what they should be prepared for in terms of scrutiny from fiduciaries, what contracts and reviews of contracts they might expect. That may be helpful if you have some ready points to talk about. Back to you. And sorry to interrupt you, Sarika.
So I can take that question from an implementation point of view. And Gauri, of course, please add Rajiv and Gauri. So Shrikant, you're absolutely right. So while directly, it doesn't really call out any penalties for the processor, but if you look at the act and now the rules as well, it talks about elements such as contractual obligations to be enforced on the processors, and it also talks about due diligences to be conducted on these processors. So and this is what I personally say, right? As fiduciaries, you only have the data protection board looking at you. As processors, you have so many fiduciaries looking at you. So actually, processors need to take it more seriously, because you will have so many more contractual clauses coming your way. You probably could be subject to audits by various fiduciaries, so have probably a mechanism to say how can that be unified, because you don't want to be hit by so many audits through the year. But definitely, if you look at contractual clauses, the TECOG measures and the reasonable safeguards that the rules now talk about, right? So whether it's to do with access management, to do with logging monitoring, to do with backup, to do with encryption, etc., etc. So all those obligations will get passed on to the fiduciary contracts as well. So you can expect those. So proactively as fiduciaries, we would recommend that, what a fiduciary, as processors, sorry, we would recommend that what a fiduciary has to do. And if you are performing any task on behalf of a fiduciary to do with personal data, then inherit those obligations proactively, right? So that you can go back and represent to the fiduciaries to say that we have done this proactively. And of course, you do have, say, a SOC 2 attest report that you can get done. You can also get done maybe an ISO 27001 certification kind of, measures that can demonstrate your intent as well.
Thank you, Mini. Now I would request.
I'll just add, what is one other important thing I think organizations should start looking at is the insurance cover, right? In terms of whether statutory liability or contractual liability. So whether you are appropriately covered through insurance, even for the data processors, because contractually, that the liability back to back may still come to them, though not statutorily. What is going to happen, because this was one of the questions that was asked to me before, that what's the reps and warranties that you're going to cover as a fiduciary in your contract. So if I'm looking at from a fiduciary perspective, I'll definitely have to go much beyond just reps and warranties. As Mini said, there will be audits and all of that. So if we have to look at as a processor, I would rather conduct myself, even if I'm not got certification or otherwise, third party audits, keep my reports ready, so I'm not sort of subjecting myself to multiple audits. I have a third party report available which I can present to the fiduciaries along with the, of course, insurance cover that I will want to protect myself. So
so I just want to add one thing, and this is more from a practical experience. So some of our clients have received mails from CERT, which is that Computer Emergency Response Team. They're always browsing the dark web to see where the data is and whether it belongs to you. So this specific person received a mail that 21 lakh customer data belonging to 21 is there on the web. Can you confirm whether it belongs to you? And if it does, what steps you have taken to ensure breach? So when we got into the facts of the case, we actually found that when the client was moving his data from server A to server B is when the breach happened. Now it happened at the data processor level. But end of the day, the CERT has taken the data fiduciary to task for not having all the right systems and governance and precautions and reasonable security guards in place for data breach. Because they are saying you are the ones who should have the system to ensure that whenever data is moving from point A to point B, what were the steps you were taking to ensure protection? So they did come out heavily on them, and they had to redo their system to ensure that no leakage happens. Similar other cases, but this was a live case which I was currently handling. So CERT is watching, they are browsing, and even if we don't report or repeat, and there's a repeat, they're the ones who are going to follow up to say what's happening. So watchdog already exists.
Thank you. Now we open the floor for a few questions. Can you please raise your hands and then I'll call up the names. As of now, Praveen Sharma, you've already risen your hand. So over to you, Praveen. Please unmute yourself and if you want to switch on your video as well. Please ask your question.
Yeah, thank you, Sarika. I represent the ISP community, the Internet Services Provider community, and therefore my questions will be from that perspective. One, it is important for us that there are certain enterprise only players in the market. So for them, because it is not a personal, but it's an enterprise base, so enterprise do not get covered under the definition, and therefore they should not get covered, those who are doing only enterprise services. Second, the volume and sensitivity definition to exclude smaller players from the definition of significant data fiduciary. All are data fiduciaries, but if you do the volume and sensitivity definition in an appropriate manner, so there are 2,000 ISPs and some of them have got 200 customers, 500 customers at a district level. For them to have all those controls and systems will not be a practical thing and will not be possible. Third thing, the penalty clause up to 200 crores or up to 250 crores is very dangerous. From our experience in the telecom sector, since it was up to 50 crores, each penalty was 50 crores only. And now in the new act, they have now graded the penalties in a proper manner. So that model of penalty and how the penalty is to be imposed, including the right to do the correction once, that if that kind of model can be brought in the rules, and because that will be harmoniously constructed with the provisions of the act itself. So what we need to do is pick up those provisions from the new Telecom Act and put it as a part of the rules. So these were my three submissions. Thank you so much.
I may just respond to that. You're absolutely right, and this is going to be one of the last point that you mentioned. We are going to make that suggestion to MeitY, that section 33 gives guidance, 33.2 gives guidance as to what all elements will be looked at while assessing the penalty. As you mentioned, even RBI has, for compounding, given some graded approach. So if the board can form its own SOPs, right, and there we have some visibility on those SOPs as to how they are going to determine the penalties and have that graded approach, it will give some kind of certainty to the organizations, even while taking your insurance claim, etc. So that is definitely going to be our recommendation, and thanks for bringing that up.
Yeah. Praveen, I just want to highlight something to you. Last year budget had a budget allocation of 1 crore for setting up a data privacy board. This year they've come back with a 5 crore budget allocation for a nationwide data privacy board managing to control all the states and so many stakeholders. So take it that there is a self-funding mechanism which may come about, and what Gauri also rightly pointed out.
This will be very unfortunate if they are looking at it as a revenue exercise.
Yeah,
then it is very unfortunate, sir.
Yeah, so there's an urgent need to represent, because the penalties are there in the act, but how we can soften the blow is where we need to make a very strong presentation.
Yes.
To ensure that it gets heeded to, at least for the internet services providers.
Penalties cannot be treated as revenue for the government, sir. If they start treating it, then it will become a penalty Raj instead of license Raj.
I never said that. I just highlighted a provision in the law.
Thank you, sir.
Thank you, Praveen ji, and thank you, Rajiv ji and Gauri. Anybody else? If there's anybody wants to have any question, please raise your hand, and then I can call up the name. I think few of the questions which have been put in the chat has already been answered by our colleagues from the EY team. So I think those are being taken care of. If anything is unanswered or anybody else has new question, please raise your hand.
Right. I have just one comment, Sarika, Mini and Gauri. Obviously, there have been 3 roundtables which have happened. So if anyone has any specific comments, concerns with a case example, if they can be sent to us, then they can be built as part of the recommendation. And then we can take it forward as a combined FICCI representation.
Sure.
Sorry, I'm unable to raise my hand. This is Yogda from American Express. Can you guys hear me?
Yes.
Yeah, we can hear you.
Yeah, great. So I think one of the questions that I have is around, and I'm not sure if this is answered in the chat. I was just trying to review. So it's more around the Apprenticeship Act. And how I'm relating the two is because there's a lot of personal information of an employee who is maybe an intern or an apprentice that's put on the NAPS or the NATS portal as we speak, which includes their PAN, their Aadhaar, not their PAN, but their Aadhaar card and their educational qualification certificates. And we've also kind of got a vendor who is doing a lot of this for us. So Amex information is going to the vendor, and then a lot of the candidate or the employee information is going on the government side. Is there any scope of, us falling into a category for risk here? And what is it that we can do at an enterprise level to safeguard ourselves?
So, if I may come in, this issue has been raised not only for, the point that you mentioned, even MCA website and other websites of the government, right, where they are freely, sharing the data. But as you know, this being a horizontal law, this law will apply even to the government. And I'm aware, I'm not able to share much here, but I'm aware that, that the government departments themselves have begun to, visualize as to what does it mean for them from a compliance perspective. And wherever we find this, as a FICCI committee, if we want to share this with the government, that these are the government departments which specifically need to look at data minimization, data sharing, and all of that, because even for subsidies, etc., we are told that sometimes information that is required more than what is required for the specified purpose is even collected in the forms, right? Even from that point, right? So I think the government itself will need to comply, definitely, for sure. And if we can point these instances out to the government departments, they will definitely need to sort of revisit their practices. And you're absolutely right, because if this is not done, there is that, sort of exposure in terms of data leakage and data sharing, which is not contemplated under the new scheme of the Act. So please feel free to share that, and we will share with the government.
And just to add to what Gauri is saying, right? One is, of course, the government. But when you're sharing the data with the third party, please do so in secure manners, because the last thing you want, like Rajiv had pointed out, the breach happened when they moved from server 1 to server 2. So the last thing you want is when you're transferring this data to any other external party to put it up on the website, that's where, say, the breach happens. And of course, the required obligations that you will impose on this third party who's working on your behalf.
Right. Yeah. Is sending secure the only option? Sorry, Rajiv, just I think more from an enterprise standpoint, is sending secure will that encompass and safeguard us? Or is there any other thing that you guys would recommend?
There are multiple elements. One, of course, is, when it comes to data privacy, there are elements around consent, there are elements around safeguarding, of course, but contractual clauses that we talked about is another element that you will need to put in place. Ideally, the mechanisms of sharing data should be kind of straight through without any human intervention, so that the more you have human intervention, the more, it's subject to compromise as well. So there are multiple, these are just examples, but of course there are multiple. Thank you.
Right.
Thank you. Rajiv, you were saying something, sorry. Please go ahead.
I wanted to say two things. One is obviously a representation, and then taking the act and the rules on the face value, the way they are, and assuming nothing's going to happen other than a small tinkering, which is there because they've taken 16 months to come out with a draft. Now, if that be the situation, then what you need to do is look at the Apprenticeship Act, see what are the statutory things that you need to follow. Look at the condition of the legitimate use, build your documentation around legitimate use, and ensure that your consents, which are taken for the processing of that data, happen in the rightful manner. And the way Mini said, once it's going to a third party, can we look at an encryption, masking, so that to that extent, you as a data fiduciary have taken reasonable steps to ensure that you should not be penalized. So that's where, in the Income Tax Act also, we have the section 271(1)(c). It talks about, where there is a reasonable belief that it was not concealment of income. It's a debatable matter. We need to create a debate that this is a viewpoint. We've taken the steps. Breach can happen any day. The hackers will always be one step ahead. So we build based on a legitimate use, on consent and ensure that the data, to the extent it is processed by the data processor, is of such a manner that we are safe contractually and legally.
One last question, again stemming from the same. Um, Considering we have employees directly uploading their information on the government portal, will the enterprise still be accountable in case if there is a breach? So we are basically a mediator here, or as you say that, we are the data fiduciaries in terms of we are arranging a call between the third party vendor who is helping these our employees to kind of register. But technically, if I look at it, every employee or every person, individual is putting their personal information by themselves. Will the enterprise still be accountable and fall under any kind of a breach in this case? I mean, if there is a breach, will they be accountable for it? Is how I want to ask it.
So let me share a personal data with you, rajiv.chok@in.ey.com. Send me a mail and I will respond. I think this requires a little bit of discussion, so we can have a discussion with you later on. All three of us can do that. But it's a very important point and we can have a discussion on this.
Right. And Yogda, like we've all been alluding, right? There are various scenarios that one needs to look at. There is no this or that. In this case, is it you getting them to do it versus they voluntarily doing it? There are multiple elements to be seen, whether it would fall under legitimate, whether it's your obligation at all as fiduciary. Would you really be fiduciaries in this scenario? Or is it an individual's attempt to do an activity? So all these elements would be looked at, and then you will need to decide.
So I have to intervene because there are other questions also. So let's take up the other questions, because otherwise there are multiple questions and we are already standing at 4:23. Dashmi, Aradhya, one by one, and then we take up the questions on the chat, and then we have to, in any case, wrap up the session because we are going to overshoot the time. Dashmi, over to you. Please be quick with your question.
My question I had already put in. If there is a data breach which has happened today, and since we do not have the DPDP Act in effect, so will it be, how will it be tried by the CERT? I mean, under what provisions? Will it directly go under the IT Act?
So is it CERT that you're referring to, or is it DPDPA that you're referring to? Because CERT, I mean, if there's a breach that happens, then there are obligations under CERT reporting anyways. You will need to report within 6 hours. You need to provide them with, it's a format that's available that you will need to provide all those details. So as far as certain reporting is concerned, that is active and live very much. So any breach that takes place today, please intimate the CERT.
What if the CERT intimates you about an alleged data breach?
That is happening, Dashmi. In fact, as we speak, a lot of our clients are getting these emails. They're very active right now. So when they reach out, you will see that they say, why don't you investigate and let us know what was the reason and what steps have you taken? So organizations will then need to go back, because many a times the organizations are not even aware of it. So then they need to go back to see how they can investigate. What actually led to the breach? Can they establish that? Frankly, in some cases, they don't even have the logs to be able to establish. But what the organization then needs to do is give a representation to CERT to say what are the measures that they have taken and are taking going forward to protect against something like this, both in terms of protection as well as detection. And if you don't, then you will keep getting those reminders that CERT keeps saying, send us in 5 days, then send us in 24 hours and 24 hours. So might as well work on it.
And any alleged data breach which has happened now and going forward, once the DPDP Act comes into force, will those old instances of data breach be tried under the DPDP Act? Does it have any clarity on that?
No, it's only going forward. It's only prospective law.
It is prospect. Okay. Okay.
Aradhana?
Yeah, hi. So, just my only question is, let's say, I belong from a company, who deals with this software service provider to the RWA societies. And from that perspective, if I see, I have n number of data of the residents there in our server, where we make sure, obviously, we are at the time of downloading and all, we are making the consent. We are taking their consent, okay, we will be, you are saving your data for some limited time point of time. So, my only concern is what should be the measures from company perspective which we should start taking now only, because here we are talking about, there is no quantity of this n number of data we are talking about, and that too personal. So what would be the measures which we can, start right away? What are the, on priority, and not wait till the rules get effect? Because I don't think so there will be a, more than a month timeline to get into the provisions, okay, where you have to be apply, girls, all the rules applicable.
Any of you,
So,
Mini or Rajiv or Gauri, would you like to take?
okay, so Aradhana, if you look at it, yes, there are steps that organizations have already started taking even before the rules are finalized. But from a consent point of view, right? Probably it's our recommendation. So if you look at the act, it talks about notice that needs to be provided for any data principal whose data is present in your environment. However, for retrospective data or the data that you have as of now, you can start taking consent, because like you said, you will need to look at it effectively. But what is important is notice at this point in time. What is important to have that visibility in terms of where all are we collecting the data. What is important now is, of course, then to identify what could my consent banner options be, because that is also an important task. And then, yes, as you see, quite a few organizations have started. You can start putting this up across your collection touch points so that you're capturing that consent. So the government, and we're hopeful, and of course there is a representation to say that if the collection of consent could be more prospective than retrospective. However, notice is something that you will need to give if you choose to keep personal data in your environment.
Okay. Now, let me make it slightly tough for you, because you said RWA. You would have a situation that people from different states who not necessarily understand English or Hindi may be residents there, maybe down south and everything. The law also says you need to take a consent, which I earlier highlighted was in a clear language that they are able to understand. So you may need to take a consent in one of the languages, which are the 22 languages in the Constitution of India, to ensure that you're compliant with the law. So that's another requirement that may come in. So have a look at it, do a geographical breakdown to see whether you have people who understand Hindi or English or any other vernacular language in which a consent needs to be taken, the way Mini said.
Understood. Thank you so much.
So I have Loma, Seema, and I think Rohan George. These are the last three questions which we can take. So I will request all of you to please raise your question so the panelists can answer in one go, since we are already at 4:30. Lomash, over to you.
Sure, ma'am. Thank you. Thank you for the opportunity. So I work with UB. So we are a fintech. We work in fintech space. So we provide software services to bank and NBFCs to co-lend the loans. So during this process, we are privy to PII and all the loan related sensitive informations. So in that process, I wanted to know, considering we are just data processors, but however, the significant data fiduciary definition is quite, it's very inclusive in nature. So I wanted to understand, like, is it going to include us also in terms of the, compliance expectation from us, or what is your take on that?
Okay. Seema,
okay, if
your question.
Oh, sorry.
Yeah, sorry, Srikanji, I'll come back on those things. I just want to clear, because in the paucity of the time, we just already at 4:30. Seema, your question, and then Rohan, I think you have a question. So over to you, Seema, first.
Thank you, Sarika. I just wanted to know, when we talk about getting consent, and consent is also to be taken retrospectively, meaning you have a large customer database, and at that point in time, you never had the concept of consent. But today you are supposed to reach out to them and take a consent. So what are we looking at? Do we look at a single opt-in, or do we look at a double opt-in? One, you need to write to them to say that, hey, we have your data, and this has been with us for X number of years, and it was being used for ABC matters. Now we are writing to you to notify you that we have this data. Can we continue to use it again for XYZ matters? That is one aspect for retrospective. And for the prospective, maybe your leads, your sale leads, for example, you might have to tell them that, look, we'll have to notify them that we need your consent. We'll be collecting this data of yours, and the purpose of collection would be ABC. So how are we to approach this, considering that I think many of us would have a lot of customer data lying with us in our repositories, and we'll also have future leads? Thank you.
Rohan George. Can you hear us, Rohan? Otherwise, I'll move on to the experts to answer the question. Okay, so over to you, Shrikantji. You were saying something, and then I will request the other experts.
Hi, I'm so sorry. I'm so sorry.
Yeah, Rohan, go ahead. Go ahead.
Okay, I think we have a problem there. To the gentleman, I'm sorry if I didn't quite get your name, who asked about being a software.
Yeah.
I think two things you might want to keep in mind. One is I would believe you come under the digital lending guidelines of the RBI. I think it was September or November 2023. I think there is a very clear delineation of the ownership and ability to deal with the PII, which is with the regulated entity who's possibly your client. And two, there are product and tech solutions available through the account aggregator framework that allows you to do the job that you do in terms of being a service provider, but park all the fiduciary and compliance requirements into the bank or the NBFC or whoever the financial institution is. I've left my email in the chat box. Please feel free to reach out to me. I'd love to set up a chat with you and not take up a broader session like this.
Okay, for the CMAS question, Mini, Rajiv, Gauri, would you like to come in forward?
So I think she was talking about consent. We've kind of partly given that answer. One is from a prospective point of view, of course. So notice is a given wherever we have data. We should send out notice, and there is clearly a requirement to say what all a notice should have. From a prospective perspective, we would suggest you can start taking consent. Consent has to be itemized. It has to provide clearly what are the options that the user has based on the purpose or the category of purposes for which we're taking the consent. So, for example, anything that's mandatory to provide the goods and service, that's first. However, if you need to send them marketing offers, there should be an explicit consent. In case there is an outreach that you need to do with respect to your developments, you should have consent. So one needs to identify those categories under which the consent needs to be taken. For retrospective, our recommendation would be hold on till the final rules come in, so that we will have better clarity in terms of what is, if it is required in the first place, because there is a lot of representation happening to say that let's not have consent for retrospective but prospective. But of course, notice can be provided to all data principals whose data is being maintained going forward.
Thank you. Gauri, you want to add something?
Yeah.
No,
I just wanted to add.
We are just running out of time, so yeah.
Okay, Rajiv ji, you were saying something?
Basically, just something which is in the rules that you also need to notice. Any notice that you will also give in the future will also need to have a communication link to your website, or that the person may have a right to ask for changes, amendment, corrections, as the case may be. So that's another requirement coming in.
Saranya, last question, and then we wrap up this session. Please be quick. Over to you. Saranya Roy.
Good afternoon. Am I audible?
Yes, you are.
Okay. My perspective is I've heard the entire session from the eminent panelists. So I would like to know about, in terms of third-party risk management, which I'm working on with Johnson & Johnson's consumer product division, Kendo. So what are the set of compliances that we need to look after apart from the regular, like, the BAU checks that we do as per the normal procedure guidelines? So anything specific to the third party risk, that I can look after and incorporate in my working pattern and style?
Sure, Saranya. So Saranya, of course, happy to connect on details on that. But broadly, if you look at it on a third-party point of view, all your fiduciary obligations will need to be assessed. So whether it's to do with TechOg measures, so all the bare minimum technical measures that the rules now talk about, or whether it's to do with any kind of back-to-back penalty that you may want to put in, may not be of the same magnitude, but some sort of skin in the game from the processor point of view that you may need to include. And of course, things like right to audit, things like or a report that they can submit of an independent audit of sorts is something these are some of the examples that you will need to look at in addition to the regular BAU review that you do for third parties.
Thank you.
Sarika, I'm so sorry, I just lost my audio. Can I just have a quick question?
Yeah, go ahead. We'll give you
Guys, I'm so sorry, but I just want to know whether there's a ambit for increasing the scope of the proposed Rule 15, and or is it purpose driven that's only for research purposes? So essentially, let's say if I'm a co-location data service provider where I'm not really processing personal data, that there can be some movement to exempt me from the responsibilities as a processor, because essentially even if it's not through the act, I may have contractual obligations that may come on me. So if there's a possibility of call out. Secondly, is legitimate interest something that can be seen completely different from consent, and that if I can fall squarely within the scope of it, then I do not have to necessarily take the specific nature of consent or like specific call outs where I'll be using the data. I'm seeing this more from an employee to an ex-employee perspective.
Okay, who wants to take it up?
No, what I would recommend, Rohan, is why don't you pen it down and send us a representation either in the chat box, we'll pick it up.
Okay.
Sure, Rajiv. Thank you.
Okay, so what do you Gauri, for your concluding remarks as a co-chair of the committee?
Sure. So thank you. Thank you for joining here in large numbers. We had amazing participation both on the webinar as well as YouTube, I'm told. And of course, this will be available later on as well, I believe, Sarika, for people to sort of view. So this is a great guidance, to the path that, all of us need to take. We also need to wear, because today we spoke more, from a compliance side, but as data principles, our data is going to be now more secure in the India, in our territory is the way we look at it. And we also, as data principles, have to be mindful of how we are sharing the data, what consents. There is likely to be consent fatigue, but even then, let's be more vigilant in terms of where we are giving our information, why we are giving our information, because we do have our own rights under the act as well, as all of you must have seen. So now I'm talking more as a data principle, but yes, as a co-chair of the committee now, as I've already laid out the future path, and I believe as FICCI, it is our duty to have these conversations time and again, because it is not just one time discussion that is going to sort of suffice. As many rightly pointed out, a lot of training will be required. So we may be conducting additional discussions as a committee for specific discussions, for example, employee related data processors, what you should be doing, right? So next few months we will align some additional webinars, so please participate in those as well. Please do send specific queries in advance for those topics so that we can cover them. So back to you, Sarika, and once again thanks EY team for actually taking the lead on this and sort of giving your perspective, and really appreciate your guidance for the industry. On behalf of FICCI, we thank both of you, and back to you, Sarika.
Thank you, Gauri, and thank you, Gauri. You've already done my job, so you've already thanked the speaker, so I don't need to speak much. We are already thankful to the EY team for this webinar, and like I said, this is not the destination; it's a journey which is started, because now the process of compliance and getting on board is the main thing which comes into picture. It's for just not the rules. So the questions may come up while the process is on. So as FICCI, we will be happy to support our members in that process, and we will be happy to host more webinars as well, in-person discussions. Please stay connected for the ease of others and those who have been asking the question. The recording of this would be available on YouTube, so you can refer it at any point of time. So that makes a life easier for those who have not been able to attend in full or want to share it with your peers. Also, if any of the questions were not answered or we were not able to take it up, I would request you to please reach out to the secretariat and we'll get back to the experts for their answers, and we'll get back to you on that part. With this, we wrap up this session. Thank you all for joining. Before we end up, can I request the speakers and as well as the participants who wish to please switch on the video so that my team can take a photograph for the webinar which we had it for this subject. Requesting the speakers definitely and the participants whomsoever are comfortable on this part. Please switch on your videos. And the secretary kindly do the needful, please. Sudhir, was it done?
Yes, ma'am. Just a second. Yes, it's done. Thank you so much.
Thank you. So I can only say
Thank you,
this is
everyone.
the subject which actually gets unity in diversity because it applies across all sectors. So everybody has to come together to make it happen in the rightful manner. So thank you all with this note, and we stay connected. Thank you, speakers, and thank you, delegates. Thank you.
Thank you, everyone.
Thank you.
Cheers.
Have a good day.
Will you take it?